Hello, everyone. My name is Daryl Triplett, and I am a certified training instructor for over 25 years. And the courses that we're going to be bringing to you today is going to be courtroom demeanor. Now, courtroom demeanor is very, very, very important for security personnel and law enforcement personnel, particularly, like I said, in courtroom situations. A lot of times when we're called to court, it's months, even years later. So, of course, your note taking and your reporting is going to be crucial in your role in testifying in court. But we're going to go over the fundamental basics of testifying in court in courtroom procedures here. Number one, courtroom demeanor. um, okay, so there's going to be two types of courtroom testimonies that you will have to give. Okay, the first one will be either a civil case where someone has done something wrong to someone and they're suing them civilly, or a criminal case where someone's broke the law. You were the first to respond, or even not the first to respond, or second or third to respond, but you were there, and the defense attorney and the prosecuting attorney is wanting your testimony. And it's always usually going to be like one side is alleging that the other side has committed violation of the law. Both sides are attempting to prove the other side wrong. Okay. Each provides evidence and testimonies to provide their cases. That will be the reason why you were there. They will call other witnesses. They will call expert witnesses. They're going to call maybe paramedics that's been to the scene. They're going to call maybe victims or suspects, even for that matter. Each side's job, whether it's the prosecuting attorney, the person who's prosecuting the case, or the defense attorney, someone who's defending the case, their job is to make sure that either it is prosecuted to the fullest extent of the law or it is defended to the fullest extent of the law that the law allows. So your role in this is very, very, very important when it comes to courtroom testimony. Now, the first thing that is very important is first impressions and how you present yourself. So if you're going there like a slouch and you're leaning over and you've got your hands up on the witness stand like this, and you're leaning over and you're just looking crazy, you're not put together correctly, your uniform is not sharp and put together, you don't make eye contact and stuff like that, how you present yourself is how people are going to take you. Be neat and project a positive appearance, or it could look just totally unprofessional. So one of the things that we want to do is always maintain a professional sight when we're on that stand and when we're in that uniform. Okay. Another one is chewing gum and wearing sunglasses. We just talked about that. Chewing gum up on the stand is totally unprofessional. Like I said, you need to present yourself as neat in appearance as you can, and up there smacking on gum and stuff like that is just totally inappropriate. Dress conservative if not in uniform. And that's important. So for my ladies who may be watching this, you want to make sure that you're dressed very conservative. Blouses button all the way up, very conservative, very neat, very chic, very clean. For my guys, no muscle bound t-shirts, no flashy clothes, no pimp hats, no nothing like that with the feather come out, nothing like that. We want to be, if you're not in uniform, in business attire, suit, tie, dress professionally. Your demeanor while you're in court. Now, be advised of this. You're going to always be under a visual scrutiny and security by the judge. They're going to always be sizing you up. Is this officer credible? Is he acting professional in court? Does he have his notebooks together? Is he reading from his report? Do I think he's lying? Those are all the things that the judge and the jury will be looking at you, judging you on. So avoid any loud comments. So, for example, if the jury or if the defense or the prosecuting attorney says something and it causes an emotional eruption in the courtroom, you are to remain professional. You're not, oh my God. You can't be with the rest of them, right? You have to maintain a calm, cool, professional attitude and a look, no matter what goes on in there, because you are going to be the one that's the officer that's going to get up there and have to testify. So if you're emotionally charged, then they're going to be emotionally charged, and it's just not going to look good. So control your emotions while you're in court. Control your body language is another one. You know, if you're up there doing this, and you're the officer, that how is that looking to the victims, family, and all that other good stuff, right? So we have to be very, 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 very cautious on how you what emotions that you have. So get a good night's sleep before. Make sure that you're well rested. Eat a good little breakfast before you come in, and come in with an objective attitude with the case. Because remember, this isn't personal. This is just strictly business, right? This is you. You were paid as a professional to handle a situation, and you're being paid as a professional now to go to court and to give your testimony of what you've seen, the facts of what you've seen. So take the emotions out of it. There's nothing to be emotional about. Just give them the facts. Under your courtroom testimony, always remember this here: review your notes and your reports before you go into the courtroom. So the night before, generally what I do is I'll go back and read my report, right? B, view my body camera and make sure that the two matches up together and that I know what I'm going to say in court. Body cameras are the best thing that's ever hit the face of this earth, in my opinion, because sometimes in stressful situations, your mind goes blank. You can't remember. You can always go back and rewind that body camera and get the footage exactly out how it happened. So your report can reflect exactly what happened. So therefore, whether it's months or years later down the road, when you have to go to court, guess what? You can put that case number in there, or however you look up your reports or your whatever. You could read that report verbatim, what it is. And then also you could view your body cam footage also. So go over your notes and your reports the night before. That way it's fresh in your mind. A lot of times we make several cases throughout our careers, hundreds and hundreds of cases. And this case may not go to court for, excuse me, for years. And you may get two cases confused. That's a bad thing. You don't want to do that. You don't want to get two cases confused. So therefore, you want to go back and review your notes, watch your body cam footage. Okay. Only answer the questions that's asked. I know that's sort of hard for some of you because some of you like to jab on a little bit, right? Including myself. But you want to only answer the questions that's asked. So if the defense attorney is asking you a specific question, answer the specific question. Period. That's it. Answer the specific question. Answer responsiveness to questions. Avoid volunteering information. Avoid answering too quickly. And understand the question. Now, I'll tell you one of these I got tripped up on one time before in court was I was sort of predicting the judge's question to me, and I was answering them before she asked the question. And she was like, "Can you let me ask the question first?" I was like, "Whoa, wow." So that was a lesson learned for me, right? And I've got 30 years in the game, but sometimes when you get in a repetition and you know sort of your stuff, you want to just get it out and out the way. And you've got to be cautious of that because she doesn't know what you know. And, you know, after, getting a little egg on my face, I had to realize, yeah, she doesn't know what you know. So just let her ask the question, calm yourself, and then answer the question after she asks the question. And that's it. And make sure. Another thing is if you don't understand the question, um, can you repeat the question? Okay, all right. I still am not clear on the question. Could you please repeat the question again? And then you sit there and then you dissect this question, what they're asking you in your mind, and you formulate a truthful answer to it. And again, you don't want to just blurt out and volunteer information because it could hurt your case, right? It could hurt your case. So only answer the questions that are asked to you in a professional manner. Make sure that you don't use slang, street language, police talk or jargon, medical talk or jargon, or anything like that, especially if you have a jury there. Because remember, a jury are everyday people who probably know very little about law enforcement. So if you go using, well, yeah, he was signal 50 when I got there, and then I figured out that he was signal 83, and then so that time they're not going to know what you're talking about. They're going to think you're crazy sitting up there on the stand. So use plain language when you're speaking. Speak clear, concise, and look the jury in the face, or the judge in the face, or the prosecuting attorney in the face, or the defense attorney in the face with confidence, and answer the question. Be as verbatim as possible. Address the judge as Your Honor. And keep your answers short and answer all questions truthfully. So I can tell you now that being as a matter of fact helps you. You don't want to go on and on and on with the story. If in your report you walked in and the suspect said, "Yes, I smacked that bitch," then in your report verbatim, you should put, or verbatim, you should put, "Yes, I smacked that bitch," in your report, in quotes, right? When you go to court and you're going to testify on the stand and you raise your right hand and you swear to tell the truth, the whole truth, and nothing but the truth, so help you God, that is what you're testifying to. That is what he said. You're not saying that. He said that, right? And that may sway the jury that, hey, maybe this guy isn't such a good guy because he's saying that, or maybe it may help the prosecuting attorney get that point across to the judge in a courtroom, right? Always keep your answer short. Again, nobody likes a chatterbox, and then also when you chatter, you may bring up other stuff that no one's even looking for. Now you've done open Pandora's box over here, and then now you're all off the subject over here, and now the defense attorney has got you on something else. So answer the questions short, quick, and at all costs be truthful. I've had to say on the stand before that I do not recall. And it has pissed some prosecuting attorneys off before, but I'm not perjuring myself in court. That is a criminal charge, and they can hold you in contempt for that. More importantly, it's against our oath of office and our duties as security officers and law enforcement officers. So it's okay if you don't remember. So if you go back to that body cam footage and you can't find that body cam footage, or you're fuzzy on a report or something like that, always tell the truth. If you cannot remember, just say, Your Honor, jury, prosecuting attorney, defense attorney, I cannot recall. Period, point blank. That's it. That's an honest answer. If you can't recall, you just can't recall. Okay. It's better than sitting there perjuring yourself, because the minute you try to perjure yourself and lie and give a whole other different story, sure enough, they're going to come up with a civilian's bot or a civilian's cell phone camera that proves you totally wrong and a liar. Now you're stuck looking like a liar and your credibility is shot. Like we said before, understand the question before answering. If you're testifying and the other side calls an objection, right? Then stop answering the questions and let the attorneys go at it. Because one of the other side is objecting to something that you're saying. So you're not an attorney, you're a security officer or a law enforcement officer. That's not your job. Your job is to give the honest truth. So when there's an objection that is raised, stop answering the question, let the attorneys do what they do. You don't need to interfere. You don't need to do anything. They will direct you on what to do. All right. Objective, speculative, right? And then the other side will argue what's speculative about this. And then the judge will make the final ruling and sustain it or not sustain it. And then you can go on or stop, and you don't have to answer no more. So that's very, very important. All right. Also, it may sound trivial, but speak loud enough to be heard, right? Because yes, you'll have a microphone in front of your face, but there may be people in the audience who can't hear you and things like that. So be sure to speak loud, clear, and concise when you're testifying in court. Courtroom practices to avoid. Now, these are things to avoid when you are in court in giving testimony. Any display of prejudices or overzealousness. Oh, we're going to get him, high-fiving in the back of the courtroom and stuff like that, right? What does that tell people? You're overzealous. You really want to get this guy for some reason. Or displaying prejudices against him. Oh, I can't stand gang members. You know, if you're in the back of the courtroom and you're saying that, you got to be careful who's listening to you. Or when you're on the stand. You know, a lot of times people will try to trap you up and try to get you into different prejudices and stuff like that. Well, isn't it true that you hate all gang members? That's why you joined the gang unit. So you got to be careful of those questions, because they will come at you to try to discredit you. Arguing with the defense, that's a big one. A lot of times they will try to bait you into an argument. All right. That's not our job to sit here and argue. Our job is to give the facts as we know them truthfully to be. Our job is not to sit up here and to argue with the defense attorney about what he may or may not say. If you cannot recall, you just cannot recall. Well, aren't you supposed to be a smart officer and recall it? I cannot recall. All right. Well, in your report, it says, well, we're going to stick to the facts of the report. If that's what it says in my report, then that's what it says in my report. But the other part, I cannot recall. Right. So they may get pissed with you. They may get out of control with you. Don't take any of that personally. Our job is there to testify, give the truth, and nothing but the truth, and the honest testimony as we remember it at the time. All right. Remember, a lot of things that we go on are very serious cases, especially if they're criminal, murders and stuff like that. A lot of security officers are first on the scene of murders and stuff like that. So you don't want to be in court joking and playing around with other officers, and this person just lost their loved one, and they think that you don't give a darn about them because you're in there joking around. So we have to be considerate of how we look. Our presentation is everything. All right. Failing to look directly at the person that's asking the question. That's another one. We talked about that earlier. Look directly at the person that's asking the question and answer it. All right. Stalling the answer. Of course, if you know the answer, just say it. there's nothing wrong with thinking about it before you say it and collecting your thoughts. All right. And I will tell that to anybody that, excuse me, can I just have a second, please, to collect my thoughts? All right. I want to give the honest, truthful answer here. Okay. And there's nothing wrong with that. But when you're sitting there putting little lies together as you go and things like that, that could be a problem for everybody. Okay. So you don't want to do that. Explaining your qualifications and experiences. Okay. You want to avoid doing that because as soon as you explain your qualifications and your experiences, they will dig you on something so small that will make you look so crazy. All right. So, for example, if this is a heaven forbid officer involved shooting, and you go to court and you're testifying, and you get up there and your chest is poked out, and you go, "Well, I'm an expert sharpshooter," right? And you shot, let's say, 2 rounds, and one of the rounds missed and hit a building or hit a car or something else, then that defense attorney will nail you on that. Well, if you're such a sharpshooter, how did you A, B, C, D, E, F, G? All right. Well, the sharpshooters do this A, B, C, D, E, F, G. So were you actually meaning to kill my client? A, B, C, D, E, F, G. All right. If you're a sharpshooter, you could have shot him in the leg or the pinky toe. You see what I'm saying? So you never want to brag on your experience or your qualification. You never want to brag on that. Yes, I did pass the state mandated qualification course. Okay. No one cares that you're a marksman other than for your own personal use, or maybe your department cares or your security department cares. But other than that, keep it very professional. Keep your qualifications to yourself. Now, there may be times they may ask you your qualifications. It's okay to tell them your qualifications if you're certified in something, right? So, for example, well, how long have you been doing security? Well, I've been doing security for 24 years, right? That's a question that was asked. That's a question that was answered, a truthful answer, right? That's not bragging on my experience. That's a truthful answer. Okay. Um, Offering opinions and conclusions can be dangerous. All right. Well, I think he had it coming, right? You don't want to offer your opinion or draw any conclusions because that's not what we're there for. We're there to testify to the facts of what we seen when we got on the scene, what we seen, uh, 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 the evidence that was collected. When did we call the police? What time did the police get there? Who arrived? Who did you turn the scene over to? What was on the scene when you got there? All that other good stuff needs to be detailed in your security report right there, right? Leave your opinions and your conclusions out of it. Uh, Being unprepared to testify. Now, that's a big one because a lot of us, we get caught up in the day-to-day hustle, and we know we got court tomorrow, but guess what? We're not prepped for it. We haven't read our report. We don't even, we say, oh, we'll do it when we get there. And then when we get there, it never goes down right. So be prepared the night before. Carrying on conversations while court is in session. Now, that's one that'll get you in trouble. And also the other one before that, which is late to court also. You want to leave out in plenty of time from your house. So if you know if you know you live an hour away, then you may want to leave out an hour and a half for traffic and stuff like that prior to the court. All right. Uh, uh, Horse playing around in court, carrying on. I know you may see other officers that you haven't seen in a while when you get to court, and your natural reaction is hey, how you doing? In court, a courtroom, that could be very detrimental. In a courtroom, you don't want to horseplay around and high five other officers and stuff like that. Carrying on conversations while court is in session It could be very detrimental, and you could be checked by the judge also, which is very embarrassing, and he could impose a fine or contempt. Okay, defense tactics. Now, you got to understand they're obligated to provide their clients the best possible defense that they can. Okay? That's what they're being paid to do. And if that means making you look bad, then guess what? They're going to try to make you look as bad as possible. All right? That's their job. All right? Their job also is attempting to break down witnesses also. All right. And what are you? You're a witness. You're giving testimony. So that's their job. Their job is also to question the witnesses, their memory. All right. They're going to try to trick you up. They're going to try to make you mix things up in your mind and forget and cross your memory up and stuff like that. That's simply their job. Your job is to stay the course, stick to your report, stick to your body cam footage. Then they can't cross you up. Okay. And also testing the witness's credibility. So a lot of times they know that if an officer is a hothead, they'll say, well, is this your only use of force that you've ever been involved in? Right? And then you answer it honestly, well, no, sir. Well, exactly how many other use of forces have you been involved in where it's ended up in an innocent person or a citizen in a hospital with 132 stitches in his head? Do you see where I'm going with that? So your credibility as an officer is very, very, very important also. So that's the reason why we have to self-check ourselves when we're on the streets and we're working our duties and stuff like that. All right. Your credibility while you're in that courtroom is important. Well, let me ask you a question. So you lied about this. Are you lying about this too? Or are you confused? Are you lying or are you confused? You see how they twist it up for you, right? So that's the reason why I say you stick to the report. You stick to your body cam footage. What's at hand? If it's not good for you, then it's just not good for you. If you said stuff in the body camera that you shouldn't have said, then it's just not good for you. But you can't lie about it because it's there on tape. Defense tactics. All right. They're going to try to have you give conflicting information. They want to try to make you nervous, and they want to try to discredit you, and they want to try to shed doubt on the officer's testimony. These are the things that they do. All right. Given conflicting testimony is an issue because now, like I said, they don't know, okay, do we believe you then or do we believe you now? Right. So giving conflicting testimony is an issue. Making an officer nervous is common. What they're going to try to do is intimidate you. All right. They're going to try to discredit you. And they're going to try to shed doubt on the officer's testimony. Now, trial procedures is a big thing, and you need to know how to conduct yourself in trial procedures. The first thing that you will see is both sides will give an opening statement. The prosecution will always go first. It's just a general rule. Prosecution goes first. The defense then presents their case. And then the officer is usually called by the prosecution. Okay, so that's the people who are bringing the charges against the person. The defense then cross-examines the officer. So once the officer gives their testimony, then the defense gets to now ask the officer questions and we call that cross-examining the officer. Okay. Then comes, after all the facts are laid out, the closing arguments. Okay. Closing arguments, prosecuting attorney goes, defense goes. All right. Then it goes to a jury deliberation, where the jury will go back and deliberate, and they'll come back with a sentencing or guilty or not guilty. And then from that, you could either appeal it, don't appeal it, or it could be ruled for a mistrial and a new trial has to be done. Okay? So your important is paramount, is paramount in this. Pre-trial testimony, you only testify at the actual trial for misdemeanors. So misdemeanors, you're only testifying at the actual trial. For felony cases, you testify at preliminary hearings in the actual trials also you could. Okay? Depends on how the case moves along. If they're able to get a resolution, it may not even make it to trial. If they're able to take some type of plea, something like that, may not even make it to trial. Okay? This is a one where officers always get in trouble at, is subpoenas. Believe me when I tell you, you cannot ignore a subpoena. More officers, security officers, and law enforcement officers get in trouble with this. That is a notification when, where to come and testify. It's an official notice by the court. You cannot ignore that. It cannot be disregarded. Generally, you cannot reschedule them, not unless it's a life or death situation. And you always have to respond to a subpoena. So remember this here, if you're under a subpoena, communication is key. All right. If you have a legitimate emergency and you can't make it for a legitimate emergency, you need to communicate that to the prosecuting DA's office and let them know. All right. But remember, these court cases and these cases are made on your testimony, or they're lost on your testimony. I'm your instructor, Daryl Triplett. Thank you for watching.